Hello everyone and welcome back to Law Statistics. Today's presentation is based on the topic the Specific Relief Act 1963, Chapter 2nd, Specific Performance of Contracts. So firstly the introduction part. According to Indian Contract Act of 1872, a contract is an agreement enforceable by law. Every contract creates certain rights and obligations for the parties. One such obligation is to perform the contract in a way the parties intended to. When a party fails in performing their legal obligation, then the other party may approach the court to enforce the contract. In decree for specific performance of contract, the defendant will be made to perform the very contract which he has breached. Specific performance, as explained by Nelson, is equitable relief given by the court in cases of breach of contract, in the form of a judgment that the defendant is to actually perform the contract according to its terms and stipulations. Pomeroy defines it as consisting in the contracting party's exact fulfillment of the obligation which he has assumed in his doing or omitting the very act which he has taken to do or omit. Now is the section 9 which talks about defenses respecting suits for relief based on contract. In Bhisham Dayal and Sons versus State of Odisha, AIR 2001 Supreme Court, it was held that a government contract which is concluded without fulfilling the requirements prescribed by Article 299 of the Constitution of India cannot be specifically enforced. In Anjali Das versus Vidyut Sarkar, AIR 1992 Calcutta, it was held that there was the approval of the society was necessary for transfer of the flat and the vendee had already applied for such approval and had also applied for the membership of the society and the society had not refused permission. Specific performance of the contract could be granted and the owner of the flat could be directed to execute sale deed in respect of the flat and direct the society by the laws of the society. Now, except as otherwise provided herein, where any relief is claimed under this chapter in respect of a contract, the person against whom the relief is claimed may plead by way of defense on a ground which is available to him under any law relating to contracts. This section makes it clear that the defenses such as incapacity of parties, the uncertainty of contracts, coercion, undue influence, fraud, misrepresentation, etc., available in the law of contract shall be open to the defendant. Where a suit is within the period of limitation but delay has resulted in third parties acquiring rights in the subject matter of the suit or has given rise to a plea of waiver, it may be a ground of defense in a suit of specific performance of contract for sale of immovable property. Now is the section 10 specific performance in respect of contracts. Essentials for the applicability of section 10. There must be a valid and concluded contract between the parties. The contract between the parties shall not be such which cannot be specifically enforced under section 14 of the Act. The plaintiff has not opted for substituted performance of the contract under section 20 of the Act. The contract related to trust shall not be such which is made by trustee in excess of his powers or in breach of trust. Now is the Amendment Act of 2018. Under section 10 of the 1963 Act, as it stood before amendment, the court had the discretion to grant specific performance of contract. And as a result, this relief was granted only in exceptional circumstances. However, now it is mandatory for the courts to grant specific performance of contract subject to the limited grounds of refusal prescribed. The very nature of the Specific Relief Act has been changed from a discretionary and equitable relief to a mandatory and statutory one. Section 10 used an expression the specific performance of any contract may in the discretion of the court be enforced. Thus, intention of the legislature at the time of enactment of the act was deemed from the expression that relief under section 10 is purely an equitable and discretionary relief thereof. This discretion existed even when the plaintiff to the suit has proved the condition that, firstly, the actual damage due to non-performance was unascertainable or the compensation in money for non-performance would not afford adequate relief. The unamended provision of Section 20 specifically stated that the jurisdiction to decree specific performance is discretionary and the court is not bound to do so merely, it is lawful to do so. Therefore, as a result of Section 10 and Section 20, in a suit for specific performance of contract, the court often award damages for breach of contract as a general rule and grant specific performance as an exception. Damages do not fulfill the ultimate purpose of the contract, that is, the execution and performance thereof. It fails to achieve what the parties sought to achieve. Thus, discretion to grant damages in a suit of specific performance of contract could not serve this justice to the aggrieved party. The Section 20 has now been substituted with another provision related to substituted performance of contract. The ultimate effect of the amendment is that the plaintiff can now claim specific performance as a matter of right. The whole purpose behind the significant amendment is to promote the promptness and efficiency in the field of contractual performance and to remove the uncertainty in the performance of contracts in order to encourage parties to enter into developmental agreements for rapid economic growth of the nation and overall development of the country. Now is the R. Lakshmi Kantham versus Devaraji Supreme Court case of 2019. Delay to file a suit for specific performance is not a ground to deny the relief. It was filed within limitation period. In India, it is well settled that the rule of equity that exists in England does not apply, and so long as a suit for specific performance is filed with the period of limitation, delay cannot be put against the plaintiff. Now is the Section 11, cases in which specific performance of contract connected with trust enforceable. According to Section 11, Clause 1, when the act agreed to be done is in the performance of a trust, the first case suggests that his competence while the other is unlawful. It has been held by illustration of the Repeal Act of 1877 that the term in breach of trust means acting in violation of the duties and obligation imposed by the trust. Specific Relief Amendment Act 2018 amended Section 11 of the Act, which deals with specific performance of the contract connected with trust. By this amendment, the words contract may, in the discretion of the court, have been substituted by contract shall. Now it is mandatory for the court to enforce a contract when the act agreed to be done in the performance of a trust. Also, in the case of Bhai Dhosbal versus Mathuradas Govindas, AIR 1980, Supreme Court, it was held that an obligation annexed to ownership of property not amounting to interest in property is in the nature of a trust and can be specifically enforced. The Madras High Court found it proper to decree specific performance of the third exempted and from sealing authority in Sushila versus Nihal Chanda Naheta, AIR 2004. Now is the Section 12, specific performance of part of contract. Section 12 provides for the specific performance of a part of a contract. This may be called as partial performance of the contract. Section 12 Clause 1 provides the general rule that the court shall not allow specific performance of a part of a contract. However, the exceptions to this general rule are contained in Section 12 Clause 2, Clause 3 and Clause 4. Section 12 Clause 2 specific relief performance of contract may be allowed if the part which is to be left unperformed forms only a small portion and admits the compensation to money. Such partial performance will be ordered when a party is unable to perform the whole part of the contract thereof. According to Mullah, the phrase admits of compensation means that there is data for ascertaining a fair and reasonable amount as the money and value of the difference between what can be performed and the express subject matter of the contract. Section 12 Clause 3 covers two situations. When part of the contract left unperformed forms a considerable part and admits of compensation in money, the court at the suit of the party not in fault grant partial performance of the court that can be performed. This can be done by reducing the amount of the part left. Also, where the party left unperformed is either a small proportion or a considerable proportion, in either case, it does not advent compensation in money. The court may at the suit of party not in fault may allow partial performance of the part that can be performed. Also, in Hanumappa Chanappa Hullur vs. Shivam Maruthappa, Parappa Kalli and others 2015 Supreme Court case. The apex court held that the appellant had one-third share in the property contracted to be sold will not bind the son, the defendant respondent being co-owner, and also the court applied the doctrine of partial performance in the above mentioned case. Section 13. Rights of purchaser or lessee against person with no title or imperfect title. The essence of Section 13 is that if the vendor or the seller does not have a perfect title over the property, upon perfection of the title, the purchaser can compel him to execute the sale. This corresponds to Section 43 of the Transfer of Property Act, while Section 13 Clause 1 Clause A deals with only sale or lease, and also Section 13 Clause 1 Subclause A does not apply to the property which is inalienable. That's all for the presentation. I hope you all enjoyed. Thank you and have a great day ahead.